Hello everyone, myself Prashant. Hope you all are doing great. We are covering fundamental rights, and today we will cover Article 12, Article 13 and Article 14 of Indian Constitution. So let's begin. Article 12. What does this Article 12 include? Article 12 includes definition of state. Why is it important, or why this thing has even been added in Constitution under article? So the thing is that when you read fundamental rights, you will come across many times this state word, right? You will see the reading of the sentence that a fundamental right is against arbitrary action of state. So what does this state means, right? So that thing is highlighted in this article 12. So article 12 says that parliament, state legislature are under the definition of state, right? Then it says all executive and legislative organ of union and state government are under definition of state. It's clear. Then it says that all local authorities are also in state definition. Then here it says that all other statutory or non-statutory authorities are also under purview of state or definition of state. Now what does this statutory mean? So statutory means any authority which has a legal backing, right? That is what statutory means. Or any authority which is established by law, right? And non-statutory is quite opposite to it, right? Now let's move to the next slide. Here a non-statutory is though non-statutory authorities doesn't have a legal backing, but they are decisions of they are official decision of government. So those also have government or they come under a law backing, right? Now let's move to the next slide. So here it says that according to Supreme Court verdict, even private company working as an instrument of state fall within the definition of state. Very important. So private company who are working for state, whether at center or at state level or at even local level, or even at local authorities level, then that particular private company or private organization or private entity will come under the definition of state, right? So now let's discuss Article 13 of Indian Constitution. So Article 13 says that all laws inconsistent with or in derogation of any fundamental right shall be void. Void means not in effect, and in other words provides for judicial review. So it says that any law which is inconsistent, right, which is not obeying fundamental right, and all laws which are in derogation, not obeying something, uh, derogation means not obeying fundamental right? So all laws which are inconsistent or in derogation to fundamental rights shall not be in effect. And how will this not in effect thing come? So it will come in picture when there will be judicial review by Supreme Court or a High Court, and that particular law will be declared void, right? Now it says that this power, that is judicial review, is conferred in Article 32, for Supreme Court, right? And this judicial review power is conferred to High Court in Article 226, that is 226. Very important to know. Now let's move to the next slide. Just give me a second. Yeah, now we are there. So Article 13. So in Article 13 the definition of law is also outlined, right? So now what does this law includes? So when you read fundamental rights, then you will come across this verbiage or this word law many times. So what does this law includes, what all things it includes? So it so what all things this what all so what all things this law word includes? So I will see that law includes permanent laws made by the parliament or state legislature, right? So it's clear, I guess. And law will also include temporary laws like ordinances, right? So temporary laws are also under the definition of law, right? Ordinances are a law only. It's not that if a bill is passed, it is made an act, then only it will be called law, right? Yeah. So one second, we have discussed temporary laws. Now it says that law includes statutory instruments in nature of delegated legislation like order, by law, right? By law, rule, regulation, or notification. So statutory instruments which are in form of order, right? Order or by law or rule or regulation or notification, so they are all included in this law definition, right? Then it says that non-legislative sources of law, that is custom or uses having force of law. So even a custom or uses which are not legislative source, right, they can or they are under the definition of law, but the thing is that they should have force of law, right? Now let's move to the next slide. So now I will discuss this article 14, which is right to equality. Very 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 important article, right? Every year questions are asked in UPSC, other state PCS prelims examination, and many times in mains examination. So it is important to know from exam perspective, and we will cover this article in very detail, right? So that everything is clear out of this article. So article 14 has two components, right? Equality before law and equal protection of laws. Firstly, we will cover equality before law. What does this equality before law means? So it firstly we need to know the origin. So equality before law has British origin. It comes from British, right? And from British constitution or British parliament, and it is a negative concept, right? Why is it a negative concept? We will know later on through the points. It says that absence of any special privileges in favor of any person. So since there is absence of any special privileges, in favor of any person, that is why it is a negative concept. And it is even for the state as well, right? No special privileges in the definition of that state meaning, right? Then it says that there will be equal subjection of all portion to the ordinary law of the land. So everyone will be equal, the law will be same for all portions residing in the country, right? And here it says that no portion is above the law. No portion, no one. I hope it is clear, and that is why it is negative in concept, since it is imposing limitations. Everywhere we are seeing no person is above the law, equal subjection of all person, right? Absence of any special privileges. So we are seeing here absence, then no portion. So all these imply all these things imply that it's a negative concept, right? Now let's move to the next slide. So here so we discussed equality before law, first component of this right to equality. Now we will discuss equal protection of laws, right? So the origin of this equal protection of laws is American origin, right? It is a positive concept, very important, opposite to equality before law. Equality before law is a negative concept, and this is a equal protection of laws is a positive concept, right? Then it says that equality of treatment under equal circumstance. So everyone will be treated equally under equal circumstance, right? This is very important. So what does this mean? So this basically means that everyone will have equal treatment, and their treatment inequality will be based on their circumstance, right? So this is what it says. And the next point says that there will be similar application of same laws to all person who are similarly situated. So similar application of same laws to all person who are similarly situated, right? Then it says that like should be treated alike without any discrimination. So it is clear. So this is a positive concept, very important, right? So here it says that in equal protection of laws, it says that like should be treated alike without any discrimination. We already discussed it, right? Here an interesting point to note is that Article 14 forbids class legislation. Forbids means prohibits, right? Article 14 prohibits class legislation. There cannot be class legislation in our country, right? Now since we have discussed Article 14, all the important points of this Article 14, now we need to know the what are the exceptions to right to equality under Article 14, right? So there are many exceptions to this article, right to equality. We know right to equality is under Article 14, right? So what are those exceptions? So exceptions are that president and governor are not answerable to any court for exercise and performance of powers and duties of his or her office. So it is clear here president and governor both have this special we can say special power or special immunity, right? Then it says that there will not be criminal proceedings instituted or continued against president or governor in any court during his term of office. So no criminal proceedings can be initiated against president or governor in any court during his or her term of office. Very important. So it's talking about criminal proceedings and during their term of office. These two words, or these two words are important to know: criminal proceedings and term of office, right? Now let's move to the next slide. So here it says that no process of arrest or imprisonment shall be instituted or continued against president or governor in any court during his term of office. So it's clear there cannot be process of arrest as well as imprisonment of president and governor in any court during his term of office, right? So we are seeing a lot of immunity for the constitutional posts such as president and governor, right? There are a lot of exceptions in case of equality for president and governor. They have a special power and immunity. Now here it says that there will not be civil proceedings against president or governor in any court during his term of office in any court, whether acts done before or after entering office, until the expiration of 2 months next after the notice has been delivered to him. So it means this statement basically means that there will not be civil proceeding instituted against president or governor in any court during their term of office, right? whether the act was done before entering the office or after. If civil proceeding is to be initiated, then firstly the notice has to be delivered to this constitutional post, right, to the person. And there and after delivering the notice, till the period of 2 months, there cannot be civil proceeding. So it means this only, right? So there is this 2 month period scenario in case of civil proceedings for the constitutional post of president and governor, when civil proceeding is to be initiated, right? Then it says that no person shall be liable to civil or criminal proceedings in respect of publication in a newspaper or substantially true report of the proceedings of either House of Parliament or state legislature. So a person shall not be liable to civil or criminal proceedings in respect of publication of anything in newspaper that is true, right, that happened in reality during the proceedings of the House of the Parliament or state legislature. So even though if it's offending or offensing, or it is that thing is something which is offending, but if that particular thing has happened in Parliament, in the proceedings of Parliament, then that needs to be then that thing can be brought in the form of publication in newspaper, and the person who brings that things in publication in a newspaper is not liable to any civil proceeding or criminal proceeding, right? Now let's move to the next slide. So here it says that no member of parliament or state legislature liable to proceedings in any court in respect of anything said or voted in house. So basically this immunity is for parliament, right? Anything can be said or voted, and this is also in bid to maintain parliamentary sovereignty, right? Parliamentary sovereignty. There can not be interference of anyone. There cannot be interference by anyone on whatever is being said or whatever is being voted, right? And here legislature are not liable to any proceedings for what they have said or voted in the house, right? Then it says that article 31C is exception to article 14. We will see this article later on, and then we will discuss what this article 31C means, right? So this then it says that foreign sovereign rulers, ambassadors, diplomats enjoy immunity from criminal and civil proceedings, right? So foreign rulers, ambassadors and diplomats, all these positions enjoy immunity from criminal and civil proceedings. Then it says that the UNO and its agencies enjoy diplomatic immunity. So UNA and its diplomat and its agencies and its diplomats enjoy diplomatic immunity, right? So I hope I have covered all the important points in article 12, article 13 and article 14. Next we will be coming up with article 15, article 16, article 17, and ultimately we will cover all the articles of fundamental rights. So thank you for your time. Thank you so much. I hope you learned, you definitely learned and enjoyed this video. So thank you again. Thank you so much.